Hello friends, welcome to my channel Civil Guru, wherein I, advocate Akshay S. Bavare, would like to begin with my very first video by discussing the rights of women under the Hindu Succession Act. Now why under the Hindu Succession Act? Because under the Hindus we have a very complex bodies in ourselves, and that is called as, there are two modes of devolution of property. One is the Mitakshara and second is the Dayabhaga. In Mitakshara, being a very complex body, a very rigid body, we are known with a very dynamic concepts such as co-parcenary, Hindu joint family, then the modes of succession, rule of survivorship, rule of succession, etc., etc. So to begin with, the rights of daughters or the rights of women under the Hindu Succession Act, it is very important for us to peep into our historical background and to ascertain how there was a change or how there was the evolution of this women's right under the Hindu Succession Act. Now when we go into the historical background, it is very important for us to understand some few concepts in a very short. The first concept of property, obviously when it comes to the succession of any property, there has to be the succession of property. There cannot be a succession of any status. So we need to understand what is the concept of property in the lights of succession. Second, we need to understand what is the concept of Hindu undivided family or the joint family. And third, we need to understand a very important concept of co-parcenary. Now why I have taken or chosen this topic today for the discussion is that there is a lot of confusion till today which is prevailing in the subordinate judiciary as well as in our minds as well as in the minds of the law students as to what exactly is the situation wherein in what manner the daughters would succeed to the right of the ancestral property. Whether they have any right in the ancestral property, and if they have, what is the sort of that right and when are they unequivocally entitled for such right. So to begin with, it is very important for us first to understand what exactly is the Hindu undivided family, HUF. Now the concept of HUF, Hindu undivided family, it is a very normal condition in the entire country. Now why I say it is a very normal condition in the entire country? Because we Indians recognize family to the very holy institution. Now when we say that a concept of family, in that family it might consist of a father, his wife, sons and unmarried daughter. Only a father, his wife, sons and unmarried daughter are considered to be a joint family. There can be a joint family in a joint family. So for example, we have our grandfather or we have our uncles, aunties, our cousins, etc. living together jointly. It also comprises to be a joint family. So also on the other hand, we may also have in that joint family a second joint family that is consisting of our brother, our unmarried sister, our father, our mother. That is also called as a joint family. So the joint family is a very common concept or a common condition of a living in our country. In this joint family, only unmarried daughters are treated to be the part of a joint family. As soon as there is a marriage of any daughter in a family, she ceases to become a member of her father's family and becomes a member of her husband's family. So by these concepts also, by way of marriage also, there can be an acquisition of rights by a daughter. Now this acquisition of rights by a daughter can be in the family of a husband as a wife and can be in a family of a father as a daughter. So these various concepts we need to look into. To starting from a very second concept, the concept of property. Now when we come to Hindu Succession Act, there are two classifications of property. First is a separate property and second is the ancestral property. Now when we say separate property could be by way of purchase, could be by way of gift, could be by way of inheritance, not from common ancestor but from some other collaterals. A classic example of separate property is my brother gifting me a property is also a separate property. It cannot be an ancestral property. When a property travels from our ancestor in a linearly descendant manner to our next generation, it is a ancestral property. So the concept of ancestral property and co-parcenary property are synonymous. So when my father inherits a property from his father is a ancestral property. So in that property, when there is a birth of mine into the family, I take an undivided interest in the property along with my father in an equal manner, and this concept is called as co-parcenary. So to a common ancestor, when lineal descendants are born, that common ancestor along with the lineal descendants create a co-parcenary. So if there is a father and a son and a grandson and a great grandson, these four of them together constitute a co-parcenary, and each one of them share equally with every person. So there is no predefined shares into the property. The shares may fluctuate by way of birth, the shares may fluctuate by way of death. So that is why we say that co-parcenary is a very narrow body and it is purely a creation of Hindu law. It cannot be created by way of any agreement, it cannot be assigned to any other person. It is a creature of law. Again, to give a classic example of co-parcenary is, if I have a grandfather, my grandfather dies, after his death my father inherits or my uncles inherits the property. Along with them subsequently me and my brother are born. So me and my brother by way of our birth acquires an undivided interest into the property. So these entire persons are called as co-parceners and the property in their hands is called as co-parcenary property. So putting it in short, a common ancestor along with his son, grandson and great grandson together constitute a co-parcenary. A fourth generation great great grandson cannot be a co-parcener unless the common ancestor dies and he is included in a third generation. So this is what the concept of co-parcenary is. Now moving forward, now we all know that before the pre-independence period, women in our country were treated in a very indiscriminate manner and in a very unequal manner. They were not classified as a heir. They were not given any inherent right into the property. For each and every right, they had to be dependent upon their male member of the family. Daughters were not having any right into the family, any right into the co-parcenary property. They were not treated to be the co-parceners. A woman, a wife or a widow, she was not treated to be a co-parcener in the property and she had no right into the property. So to deal with the historical aspects of the Hindu Succession Act, before 1956 or before the Hindu Succession Act came into picture, there was a predominance among the Shastric or the customary laws for way of a succession. The succession of any male member of a family was treated not by any particular rule of succession but by way of Shastric or customary law. Now when we say that by way of Shastric or customary law, there were indefinite rules of succession. Now we all know that there are two predominant schools for devolution of property. First is the Mitakshara and second is the Dayabhaga. Dayabhaga, not being a very complex situation, is only followed in some regions of Bengal, not in the entire country. That is why we'll deal with the topic of Dayabhaga in some other video. Today we are speaking Mitakshara and particularly co-parcenary, which is a part and parcel of Mitakshara school. So even prior to 1956, there was a predominance of rule of survivorship and rule of succession. These are the two modes of devolution of interest in property: rule of survivorship and rule of succession. Now when we say rule of survivorship, so rule of survivorship means as soon as there is a death of male member, that property not passes to his entire legal heirs but passes only to the surviving male members of the family. This was the topic of survivorship. Now when we say succession, succession means each and every persons who are classified to be the legal heir of that death male ancestor. This is the rule of succession. Now the first very important step was taken by the British India government in the year 1929. In the year 1929, the Hindu law of inheritance was passed. Now, as per that Hindu law of inheritance, three persons were classified, or three women's category of women were classified to be the legal heir of a male person. I have the extract of that, and wherein section 2 of the Hindu law of inheritance stated that a son's daughter, daughter's daughter, sister and a sister's son shall be in order so specified be entitled of succession next after the father's father and before a father's brother. So a very drastic change, a very important change to the concept of succession among the Hindus by way of Hindu law of inheritance 1929. By way of this act, a daughter's daughter, by way of this act, a son's daughter, a sister and a sister's son were classified to inherit the property of a male Hindu. But a very important drawback in this was a daughter and a widow were not included for succession. They were still excluded from succession, and this law was prevailing until 1937. So till 1937, no widow or no daughter was entitled to have any sort of share into the property of their husband or father. Now again in the year 1937, a very important act was passed by the British India government, and that act is called as the Hindu Woman Right to Property Act 1937. Hindu Woman Right to Property Act 1937. So by way of this act, for the very first time, a widow was entitled to have a share equally as that of her husband in the joint family. A very important aspect. A widow, after her death of her husband, was entitled to inherit the property of her husband along with her sons. It means that if there is a male husband and he dies leaving behind a widow and a son, so instead of the property passing entirely to the son, half share will go to the husband and half share will go to the son and half share will go to the husband. This is what a very important aspect of Hindu Women Right to Property Act was. Now by way of this act, though she was entitled to have some sort of share into the property of the husband, be it co-parcenary, be it his separate property, but this property was not or what we can say, she was not entitled to become a full owner of this property. By way of by way of section 3 of the Hindu Women Right to Property Act 1937, it stated that any interest devolving on a Hindu widow under this provision shall be limited interest known as the Hindu woman's estate. So though a widow was classified to hold a property or to classify to have a share into the property of her husband along with her son, she was not deemed to be a full owner of a property. She had a very limited interest in that property, and that limited interest was called as Hindu widow's estate. It means that she had a right of enjoyment, she had a right to take a crop therein, she had the right to possess that property, but after her death, that property will not pass on to her heirs, but it will go back to the reversionaries of the property. That means the last owner of that property. The property after the death of that widow will go again to the hands of the previous owner, the last owner of the property. This was a very, what we can say, inhuman restriction under this act. But if we go to see the prevailing conditions in 1937, definitely in that orthodox system, this act became a very fruitful for the widows. At least they were entitled for some sort of limited interest in that property. Now when we say limited interest in that property, she was not the owner of that property. She had the right of enjoyment, she had the right of possession, she had the rights to take fruits out of that property, but she had no right to alienate that property. She had no right to transfer that property. The only thing she could do is that she could transfer that property for a legal necessity. Now, as we all know, the term legal necessity is very complex in nature. We cannot know what exactly is a legal necessity. It depends upon the situation and circumstances when the widow might have sold the property, from case to case. So this Hindu Women's Right to Property Act became a very important legislation for the widows who were subjected to some sort of dominance in the Hindu families. But apart from this act, if we see that only the widows were entitled to become the successors, or they were entitled to become the heirs of a husband, but nowhere it stated that a daughter too has any similar right to have a share in the father's property. So even though the 1937 Hindu Women Property Act came, a daughter was not entitled to have any share into the father's property. So the next step came the 1956 Hindu Succession Act. 1956 Hindu Succession Act, we all know the historical background of that act, the legislative history of that act. Hindu Code Bill was introduced by Dr. B.R. Ambedkar, a great human, and after a lot of discussions, still he was not in a favor to retain the section 6, the Mitakshara co-parcenary concept, but as per the prevailing pressure in the parliament on him by some of the dominant Hindus, parliamentarians, he had to retain section 6 and he had to keep immune the Mitakshara co-parcenary. So even though 1956 Act came into picture, a daughter was not entitled to any right. But after the 1956 Act came into picture, there was a scheme of succession provided by section 8 and section 15. Section 8 to 13, it deals with the what we can say, the order of succession among males, and section 15 deals with the order of succession among females. So the drastic change what brought about into the 1956 Act is that after the 1966 Act, 56 Act came into picture, a daughter was classified to be the class 1 heir for a male Hindu. So as per section 8, which deals with 4 classes of heirs, class 1, class 2, agnate and cognate, a daughter was included in a class 1 heir. So if a male Hindu dies leaving behind any separate property, his succession would govern by section 8, wherein his daughter had an unequivocal right to succeed or to have a share into that property along with the sons or brothers, whatever it may be. Obviously the widow was also included in class 1 heir. But what was indiscriminatory on part of the woman or part of a daughter or a wife was section 6, which deals with devolution of interest in the co-parcenary property. Now the old section 6 also have made a drastic changes. The first part of section 6, old section 6, it says that if any male Hindu dies after the commencement of this act, his right shall, or his interest in the Mitakshara co-parcenary shall pass on by way of survivorship. Now here again the Hindu law 1956 have made a drastic change by introducing a proviso in the section 6. This proviso of section 6 state that provided where a male Hindu dies leaving behind a class 1 heir, his interest in the Mitakshara co-parcenary will not devolve by way of survivorship, but it would devolve by way of succession. And when his interest in the Mitakshara co-parcenary would devolve by way of succession, automatically section 8 comes into picture, wherein the death of a male co-parcener, after he dies leaving behind his interest, it would deal by way of section 8. So as soon as section 8 comes in picture, it means that a daughter and a wife were also classified to have a share in the co-parcenary property, provided the share in their father's or husband's share. This concept is also called as notional partition. There is a long history of section 6. Notional partition has been very well explained in Gurupad Makdam case, a landmark case of Supreme Court. So in that case, it was held that interest in a Mitakshara co-parcenary, it means that after a male dies intestate, we have to find out on the date of his death what was his share in the co-parcenary. If for example he has 1/3 share in the co-parcenary, in that 1/3 share shall be equally divided among the class 1 shares. So when it was equally divided among the class 1 heirs, even a female, including a woman and a daughter, or including a widow or a daughter, would have entitled to have a share in the co-parcenary property. This act came into picture. The widow who had acquired an interest by way of the Hindu Women's Property Act 1937, which was deemed to be her limited interest, that limited interest by way of section 14 of the 1956 Hindu Succession Act, it got converted into her absolute interest. The section 14, the marginal note of section 14 itself says that property acquired by any, or property acquired and possessed by any female Hindu before commencement of the 1956 Act shall be her absolute property. So any Hindu female, more particularly this section deals with the Hindu limited estate or the Hindu widow's estate. Why? Because daughters were before 1956, they were not having any share into her father's property. So basically this section 14 only deals with the widow's property. So any widow who had acquired her interest by way of the 1937 Act, which was her limited or Hindu widow's estate, that estate got converted into her absolute property. Now by way of 1937 Act, she was only the limited owner. Until her lifetime she was entitled to enjoy, to take foods from that property, but she was not entitled to alienate that property. So this drawback was converted or healed by 1956 Act. So by way of section 14, before commencement of this 1956 Act, if any female Hindu had acquired and possessed any property, be it by way of her stridhan, by way of a gift, by way of a partition, by way of a maintenance, all such properties or mode of acquisition of properties got converted into the absolute interest. So this was a very drastic and a very important step taken by the 1956 Act. So we can say that by way of this section 14, the constitutional aim of providing equality and indiscrimination among the males and females was sought to be achieved. But still the main and important drawback was left for a daughter. A daughter before 1956 not entitled to any right. But after 1956, as I earlier said, by way of section 8, any male Hindu dies leaving behind his separate property, a daughter along with her son was entitled to share the property equally. But speaking to the context of co-parcenary property, a daughter was not entitled to have any share in the co-parcenary. Still a daughter was excluded from a co-parcenary property. Now if we see the scheme of section 6, devolution of interest in co-parcenary property, it stated that when a male dies leaving behind his interest in a co-parcenary property, it would deal by way of survivorship. The proviso provided that at the time of a death of a male Hindu, if he dies leaving behind any interest in the co-parcenary property, a daughter would take equally along with the other legal heirs in his interest. This is a concept of notional partition. The concept of notional partition will be dealt by me in another video. So, for example, to give an example how a daughter would acquire an interest in the co-parcenary property is that, for example, if a father dies at 1950, at that particular time the succession for that father would open at 1950. So at that time daughter would not get any share prior to 1956, because the only reason is that the succession to the death co-partner opened at 1950 at the time of his death. But if a male Hindu dies after commencement of the 1956 Act and he dies leaving behind his interest in a co-parcenary property, the explanation provided in section 6 is that any interest shall be calculated, any share of that death co-partner in the property. So if at the time of his death, a male Hindu dies leaving behind his widow, his son and a daughter. So at the time of his death, if he had a half share in the Mitakshara co-parcenary, his half share would be equally divided among the legal heirs. That is, his half share will be divided equally among his widow, his son and his daughter. So this was again a very important change which brought to the Mitakshara co-parcenary, wherein though daughter not treated to be a co-parcener, but she was entitled to have a interest or to have a share in her father's property, who had an interest in the Mitakshara co-parcenary property. So by passing of this 1956 Act, we could say that a widow was not discriminated at all. A widow was entitled to have an interest in the co-parcenary property. A widow had an interest in her separate property of a husband, but daughter was excluded from co-parcenary. And this exclusion of daughters in co-parcenary prevailed till the year 1989 and 1994. In 1989, Andhra Pradesh, then Tamil Nadu, Karnataka and Maharashtra brought an important amendments to heal the indiscrimination of daughters in the co-parcenary. In the year 1994, the Maharashtra government brought an important amendment to section 29, where it said that on and from commencement of the 1994 Act, on and from commencement of the 1994 Act, a daughter shall have same rights as that of a son in the co-parcenary property. A daughter by birth shall be treated to be a co-parcener, and a daughter shall hold the co-parcenary property with the same incidents, and a same share shall be allotted to a daughter as to the son. So this indiscrimination was sought to be achieved by keeping in view the section Article 14 and Article 15 of the Constitution, and some sort of how the indiscrimination came to an end to 1994 after Maharashtra government passed this act in Maharashtra. But in rest of the countries still it was indiscriminatory. But a very important condition in the 1994 Act was that this provision was not applicable to daughters who were married before 1994. So on the date when the 1994 amendment came into force, this amendment, or a daughter who will be treated to be a co-parcener, only an unmarried daughter would be treated as co-parcener. Daughter, though by birth she acquired the status of co-parcenary, she was not treated to be co-parcener. The only reason, she ceased to be the member of her father's family, and by marriage she became a member of her husband's family. This was again a very important drawback, because there is a little conflict or a little controversy, because co-parcenary acquires by birth and not by status of marriage. So again, somehow some loophole were left out in the 1994 Act, but still a very good act, a very good amendment brought about by the Karnataka, Maharashtra, Andhra Pradesh, Tamil Nadu, wherein they have sought to achieve the constitutional aim of violating, or what we can say, constitutional aim of indiscrimination, which came to an end, wherein by conferment of a status of co-parcenary to the daughters, though to the daughters who are unmarried. Now comes section 6 of 2005 amendment, a very important aspect. So by section 6 of the new amendment of 2005 amendment, which again stated that on and from commencement of the 2005 amendment Hindu Succession Act, a daughter by birth shall be treated to a co-parcenary. A daughter by birth shall be allotted same share as that of a son, and a daughter shall hold or have the same incidents of co-parcenary as that a son could have had. So by way of this 2005 amendment, all the indiscrimination among a daughter and a son came to an end. But one question that is still unanswered, or one question that is still there, is that if a father of a daughter has died a long way prior to the 1956 Act, that daughter has not acquired any right into the co-parcenary property as well as the father's property. This question was treated, or was very well drafted, or was very well addressed by the Bombay High Court in the case of Draupada Bai versus Dattatreya, reported in 2019, volume number 5, Bombay CR, page number 360. So in that case, relying and referring to paragraph number 43 and paragraph number 72 of the Mullah, it has stated that by way of 1937 Hindu Women Right to Property Act, only widows acquired an interest in the husband's property. And widow along with the son, they were classified to be the legal heirs. A daughter was not classified to be the legal heir. As per paragraph number 43 of Mullah, as long as the widows are alive, daughter will not get any share into the father's property. This is what the settled provision is. So till today, one thing that is there is, if a father of a daughter has died before 1956, that daughter will not acquire any interest. The reason behind is that every section regarding the succession, it states that after commencement of this act, so the provisions of 1956 Hindu Succession Act are applicable to persons who have died after commencement of this 1956 Act. So any person who has died prior to 1956 Act, his succession opens at the time of his death. The rights of the legal heirs are crystallized at the time of his death, and that is why any father of a daughter died before 1956 have no share into the father's property, be it ancestral or be it a separate property. In the next video, guys, we will be dealing with the continuance of confusion in section 6 Amendment Act, whether it is prospective, retrospective, and referring on various judgments and its interpretation. We will try to evaluate what is the provision. Thank you.